Welcome back to the Deep Dive. I'm your host.
And I'm your expert guide.
Today we're doing a really focused exploration into, well, a fundamental area of criminal law, property offenses.
That's right. We're looking at things like theft, burglary, fraud, and that slightly odd one, making off without payment. Seems simple maybe, but the law, well, it gets complex.
It really does. And this deep dive, it's specifically for you, especially if you're gearing up for exams on this topic. We're basing our discussion today on some excellent excerpts covering property offenses.
Yeah, these were made available by the University of London for educational purposes, which is incredibly helpful. We're really grateful to them for providing these resources.
Absolutely. And we should also mention this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
And to all you students listening, preparing for those exams, genuinely, the very best of luck.
You've got this, seriously. So our mission today, to kind of cut through that complexity, we'll use the material to break down these key offenses: theft, burglary, fraud, making off.
Yeah, we'll dig into the core concepts, the essential legal bits, the actus reus, the action, and the mens rea, the mental state.
And we'll highlight those crucial cases, the ones you really need to know for your exam preparation.
Exactly. We'll take each offense in turn, look at its elements, and see how the courts have, well, shaped the law through key decisions. Think of it as navigating the map together.
Okay, let's dive in. Starting with theft. Feels like the most basic one, doesn't it? Don't take stuff that isn't yours. But legally,
Legally, it's much more precise. Section 1 of the Theft Act, 1968, gives us a definition. A person commits theft if they dishonestly appropriate property belonging to another with the intention of permanently depriving the other of it.
okay, whoa. 5 things there. Dishonestly. Appropriates property belonging to another. Intention of permanently depriving.
Exactly. 5 key elements. And the prosecution. They have to prove every single one, beyond reasonable doubt.
And we can split those into the physical act, the actus reus, and the mental state, the mens rea, right?
Perfect. So the actus reus for theft needs 3 things. 1, there must be property. 2, it has to be appropriated by the defendant. 3, and it must belong to another at the time it's appropriated.
Let's start with property then. Section 4. What actually counts? My phone, obviously, but left tangible things.
Right. Section 4.1 is broad. It covers money, real property, land with limits, personal property, like your phone. But, and this is key, pay attention. It also includes things in action and other intangible property.
Things in action. Okay, that sounds a bit like legal jargon. What does it mean simply?
Think of it as rights that have value, that you can enforce legally or turn into cash, but aren't physical things themselves, like a debt someone owes you. Or more commonly now, your bank balance.
Ah, okay. My bank balance isn't physical cash in my hand, but it's a valuable right I have against the bank.
Precisely. That's a thing in action, and it's definitely property that can be stolen. Really important point for exams, that one.
Got it. So not just physical stuff. What about land then? Real property. You said there were limits.
Generally, you can't steal land itself under Section 4.2. The usual remedy for someone messing with your land is civil law, like trespass.
But there are exceptions in 4.2, aren't there, if you're, like, connected to the land already?
Exactly. So if you're a trustee managing land and you dishonestly misuse it, that can be theft.
Right.
Or if you're trespassing and you sort of sever something from the land, like digging up turf, cutting down a tree, pulling lead off a roof and then take it, that counts.
So detaching it makes it stealable property.
Yes. And tenants can also steal fixtures let with the property.
Okay, that makes sense. Let's test this with activity 12.1 from the material. A takes B's check for £100 from C and pays it into her bank. What's stolen?
Potentially 2 things. First, the physical piece of paper, the check itself. That's personal property.
Right.
Second, when she pays it in, she appropriates the funds. The £100 value represented by the check. That's a thing in action belonging to C. So she could be charged with stealing both.
And 12.2a, using forged checks to transfer funds from B's account.
Primarily, that's theft of the funds, the thing in action, from B's account. The forged check is the tool used for the appropriation.
Okay. Any other property quirks, like wild mushrooms or animals?
Yeah, Section 3 says you generally don't steal wild plants, like mushrooms or flowers, unless it's for a commercial purpose. And wild creatures are property, but generally not stealable unless they're tamed, captive, or you've somehow already taken possession of them.
Right. Now, it's a slightly stranger area.
Mm-hmm.
Bodies and body parts. The old view was you couldn't steal a body, like in Shark.
Mm-hmm.
But the source mentions a key update.
Yes, this is vital. The old case Sharp said a body wants no owner, but things have moved on. The crucial point comes from cases like Kelly and Welsh.
Kelly and Welsh got it.
They established that if skill has been applied to a body or body part, it can become property capable of being stolen,
Skill, like what?
like dissection, preservation, preparing it for teaching or exhibition, as in Kelly,
Hmm.
or even collecting and preserving a urine sample, as in Welsh. That application of skill transforms it.
So activity 12.3. The hairdresser, collecting hair. If they process it, apply skill intending to make cushions, that processed hair could become property. Taking it then could be theft. Remember Kelly and Welsh for body parts.
Definitely. And just a quick note, getting the identification of the specific property right in the charge is crucial. A mistake there can cause the case to fail.
Okay, property covered. Let's move to the second actus re element, appropriation. Section 3.1. This isn't just grabbing something, is it?
No, and that's a really key aspect of the 1968 Act. Appropriation means assuming any of the rights of an owner. Doesn't have to be all the rights, doesn't even need you to physically take it. Just assuming one right is enough.
Like offering to sell something you don't own. That case, pith 'em in hell.
Exactly. Offering to sell is assuming the owner's right to sell. Boom! Appropriation.
What about Daru? Filling in false claim forms that wasn't appropriation of the money itself.
Not at the point of filling the forms, no. The court said that act wasn't assuming a right over the money. The appropriation happened later, maybe when the funds were accessed or transferred. Activity 12.4c touches on that.
Okay, now a big issue historically was consent. Did the owner's consent stop something being an appropriation? There was that clash between Lawrence and Morris.
Yes, a famous conflict. Lawrence, the taxi driver case, said consent was irrelevant. But Morris, the price tag swapping case, suggested appropriation needed some adverse interference, implying consent did matter, caused a lot of confusion.
How they sorted out?
The House of Lords sorted in Gomez. Gomez. Deceived manager, stolen checks. The Lords confirmed Lawrence. Consent is irrelevant to appropriation. Even though the manager consented to the goods leaving, Gomez appropriated them by dealing with them. That's a huge point. Consent does not prevent appropriation.
So activity 12.5, what Gomez did, arranging the transfer of goods, even with that flawed consent, was the appropriation.
Precisely. And this principle paved the way for, well, the really controversial case of Hanks.
Ah, yes, the one about receiving gifts.
Exactly. Hanks. Woman receives large gifts from a vulnerable man. Under civil law, they were valid gifts. She owned the money. But following Gomez, the House of Lords said that receiving the gift itself constituted an appropriation.
Wow.
And if the prosecution could prove she was dishonest in receiving it, even though it was a civilly valid gift, it could be theft.
So you can technically own something in civil law, but be guilty of stealing it criminally if you got it dishonestly through appropriation. That's counterintuitive.
It really is. Activity 12.6 points out that liability in Hanks still needs dishonesty. Most people receiving genuine gifts aren't dishonest, but the principle stands. Receiving property, even a gift, is appropriation. Hanks is key.
Okay. Third actus reus bit belonging to another. Section 5. Again, seems more complex than just legal ownership.
It is. Section 5.1 says property belongs to anyone having possession or control of it, or having any proprietary right or interest in it.
Possession or control, or are a proprietary right or interest.
Yes. So, property can belong to several people at once in the eyes of theft law. And maybe the biggest surprise, you can actually steal your own property.
Stealing your own car from the garage repair shop.
That's the classic example. Turner. Mr. Turner took his car back without paying the repair bill. The garage had possession and control and a right to keep it until paid, a lien. He was convicted of stealing his own car.
But what about Meredith? He took his car back from the police impound and wasn't guilty.
Good contrast. In Meredith, the court found the police had no legal right to hold the car against the owner, so it didn't belong to the police in the required sense under Section 5. Activity 12.7 really highlights this. Turner guilty, garage had right to retain. Meredith not guilty, police didn't.
What about stuff left behind? Abandoned property. Like in a skip.
If it's truly abandoned, it belongs to no one. Can't be stolen. But often things aren't truly abandoned. They might belong to the owner of the land or container where they're found. Think Hibbert v. McKiernan golf balls on a course belong to the club. Or Williams v. Phillips rubbish put out for collection still belonged to the householder until the council took it.
So activity 12.8, stuff in a skip, probably still belongs to the householder, like in Williams v. Phillips. Taking it could be theft.
And a really crucial timing point. The property must belong to another at the moment of appropriation. Remember, Corcoran went?
The restaurant meal.
Yeah. Eating the food is appropriation. But if you only form the intent not to pay after you've finished eating, it's not theft of the food. Why? Because by then the food doesn't exist anymore as property belonging to the restaurant. Timing is everything.
But withdrawing cash from an ATM without funds.
That's Chetarek v. Poland. The money belongs to the bank right up until the moment you take it, so taking it without authorization is theft from the bank.
The Act also has those special belonging to in other cases in 5.3 F43.
Yes. Section 5.3 is about property received under an obligation to deal with it in a specific way. If you get property and you're legally required to keep it for someone or use it for a particular purpose, and you don't, it's treated as still belonging to the person who gave it to you.
Like the charity money in Wayne.
Perfect example. Wayne. Or the flatmate's gas bill money in David V. Bunnett. But it must be a legal obligation, not just a moral one. That was the point in DPPB Huskinson and Hall, Activity 12.9.
And Section 5.4, property received by mistake.
Right. If you get property by mistake, like being overpaid, and you're under a legal obligation to return it, the property is deemed to belong to the person entitled to restoration.
Cases like Moynes v. Cooper, double salary, or Shadrach Sagari, big bank error.
Exactly. Shadrach Sagari is a key case here. The excess money mistakenly credited was deemed to belong to the bank under S.54. Activity 12.10 asks if S.54 is redundant, as maybe the property still belongs under S.5 anyway, but it clarifies the situation for mistakes.
Okay, that's the actus reus, well covered. Now, the mens rea, the mental element. First up, dishonesty. The Act doesn't define it, but Section 2.1 lists situations where you're not dishonest.
Correct. Section 2.1 is crucial. It says if you genuinely hold one of three specific beliefs, you are not dishonest for the purposes of theft. It's about your actual belief, even if it's unreasonable.
Like believing you have a right in law, believing the owner would consent, or believing the owner can't be found by reasonable steps. Those are the ones. So taking money you genuinely think you're owed, borrowing from a friend you're certain would say yes, finding cash and making genuine efforts, but concluding the owner is lost if you truly believe these things. No dishonesty, so no theft.
But the general test for dishonesty when S.21 doesn't apply, that's changed, hasn't it, from gauche to...
Yes, big change. We used to have the two-part gauche test. 1, was it dishonest by ordinary standards? 2, did the defendant realize it was dishonest by those standards?
And that second part was the problem, the Robin Hood defense, as Activity 12.1 puts it. Sort of, yeah. It meant someone could potentially get off if they genuinely didn't think ordinary people would see their actions as dishonest. But, and this is vital for exams, the Supreme Court scrapped the second part of gauche.
In which case?
In Ivy v. Genting Casinos, a civil case initially, but its test for dishonesty was confirmed for criminal law in R.V. Barton and Booth. So the current test is the Ivy test.
Right, Ivy. What is the Ivy test then?
It's now a two-stage test assessed by the jury. First, what was the defendant's actual state of knowledge or belief as to the facts? Second, in light of those facts as believed by the defendant, was their conduct dishonest by the standards of ordinary decent people?
Okay, so you look at what the defendant genuinely thought the situation was, but then judge their actions objectively against society's standards. Their personal view on whether others would find it dishonest is irrelevant now?
Exactly. The process is, check S.21 first. If one of those beliefs applies, they're not dishonest. If not, apply the Ivy test. Activity 12.13, the bruised apple, is a good example. Check S.21 beliefs first, then, if needed, apply Ivy based on D's belief about the apple's state.
Got it. Second mens rea element. Intention permanently to deprive. Section 6 helps here. This isn't just about whether the owner actually lost the item forever, is it?
No, it's about the defendant's intention when they appropriated the property. Just borrowing something isn't usually theft, unless Section 6 applies.
And Section 6.1 says intending to treat the property as your own to dispose of, regardless of the owner's rights, counts.
Yes, treating it as yours to get rid of or use up, like holding property to ransom, or exhausting its value, think using a one-off ticket, Marshall, Coombs, and Aaron, or installing stolen doors in another property, DPPV Lavender. You're essentially destroying the owner's rights.
But not just borrowing to copy, like in Lloyd with the films.
Right. Lloyd said borrowing the films didn't diminish their value or usefulness enough to count under S.6 Su.1. The goodness wasn't gone. Activity 12.15, golf balls, asks you to apply this. Could using someone's specific golf balls for a whole tournament exhaust their unique value for that person? Maybe arguable under S.61.
Section 6.2 mentions pawning something you might not get back.
Yes. And remember, for things like money, fungibles, intending to return the same value but with different notes or coins is an intention to permanently deprive the owner of the original notes coins. That's volumal. Remember volumal from money.
And briefly, conditional intent, wanting to steal only if something's valuable.
Can be theft, yes, but the charge needs careful wording. Easem versus the Attorney General's reference.
Okay, huge summary for theft exam readiness. Know the 5 elements. Property, S4, things in action, land exceptions, Kelly Walsh. Appropriation, S3. Anyway, Gomez says consent to irrelevant, Hingsung Gis. Belonging to another, S5, possession, control, interest. Turner Meredith, owner, theft, S.4, Wayne, S.4, Shadrock, Sagari. Mens rea, dishonesty, IV test now, remember S.2, exceptions first. And intention permanently to deprive, S6, Marshall Lavender, Lloyd, Valimo. Got all those cases.
That's a fantastic checklist. Mastering those is key.
Right, let's switch gears. Burglary. Section 9 of the Theft Act 1968. This one's more about the place, the building security, isn't it?
Exactly. It's an offense against the security of a building or part of a building. And there are 2 main ways to commit it under S.91 Amend 1.1.
But they share common ground, right? First, there has to be an entry. How much entry?
Doesn't have to be the whole body. The courts say it just needs to be an effective entry. It doesn't need to be substantial. Brown confirmed that, overruling an older idea. Ryan is another case guy, got stuck, but it was still effective entry. So, effective entry.
Second, entry as a trespasser, meaning without permission.
Yes, without consent, express or implied, or legal authority. Collins is the classic case climbing the ladder. But was he invited in before he fully entered? And so, maybe not a trespasser at the point of entry?
But you can become a trespasser even if you initially have permission by exceeding it.
Absolutely. Exceeding authority makes you a trespasser. The really important case here is Jones and Smith.
The son stealing from his parents.
That's the one. He had general permission to be in the house, but when he went in specifically to steal, that criminal intent canceled out his general permission. He entered as a trespasser.
So activity 12.16a, walking into a shop intending to steal. You have permission to browse, but Jones and Smith says the intent to steal makes you a trespasser immediately on entry. And 12.1's BB suggests Collins might be a trespasser under Jones and Smith if he climbed the ladder intending rape, regardless of the later invitation.
Correct. Third common feature, it must be a building or part of a building. Building implies some permanence, house, shop, barn, maybe a substantial shed or portable cabin, B and SV lethally. Section 9.4 specifically includes inhabited vehicles or vessels, like caravans or houseboats.
And part of a building.
That covers going into areas within a building where you don't have permission, like going behind the counter in a shop, Walkington, or into a private office, building or part of a building.
And the mens rea for both types. You need to know you're trespassing or be reckless about it.
Yes, at the time of entry. Plus the mens rea for whatever ulterior offense you intend or commit. Activity 12.17 confirms Collins would have the mens rea if he knew he wasn't invited and entered intending rape.
Okay, now the specifics. Section 9, a burglary.
This is entering as a trespasser with the intent to commit one of 3 specific ulterior offenses listed in S.942. Intent at the moment of entry.
And you don't actually have to do the crime, just intend it when you trespass.
Correct. And the ulterior offenses for 9 are stealing anything in the building, inflicting grievous bodily harm, GBH, on anyone inside, or unlawfully damaging the building or anything inside. So, theft, GBH, or damage. Note what's not their intent to commit fraud or rape or just actual bodily harm, ABH.
Got it. What about Section 9.1b then?
This is different. For 9.1b, you must have entered as a trespasser, and then once inside, you actually commit or attempt to commit either theft or the infliction of GBH, commits or attempts theft or GBH.
So the key difference, 9.1a is intent at entry. 9.1b is committing or attempting the crime after entry.
Exactly. And notice, for 9.1b, criminal damage is not included. If you trespass, get inside, and then just cause damage, that's criminal damage, not 9.1b burglary. Same for ABH. It has to be theft or GBH or attempts. And you have to prove all the elements of that subsequent offense.
Activity 12.18 scenarios help. Trespass into private office to steal. 9.1a if intent at entry, 9.1b if you steal after entry. Trespass into flatmate's room to borrow dress, could be 9.1a if intent to steal at entry. 9.1b if you actually commit theft later. And 12.1ec reminds us damage ABH aren't covered by 9.1.
And quickly, aggravated burglary. Section 10.
That's burglary plus a weapon.
Yes. Committing any burglary while having with you at the time a firearm, imitation firearm, weapon of offense, or explosive. Weapon of offense includes things made or adapted for injury or things you intend to use for injury. RV, Alitu, and White.
The tricky bit is at the time. When exactly?
It depends. For S.91A burglary, intent at entry, you must have the weapon when you enter. For S.91B burglary, commit crime inside, you must have the weapon when you commit the ulterior offense, theft, or GBH. O'Leary is the key case for 91B timing. He picked up the weapon inside, then committed the theft. That was aggravated burglary. Remember O'Leary?
Burglary takeaways. S91A v says B. Common elements. Entry, Brown Ryan. Trespasser, Collins, Jones, and Smith. Building part, Walkington, S94. Mens rea, no reckless trespasser, plus ulterior offense. Ulterior offenses, theft GBH damage for A, theft GBH for B, aggravated burglary, timing O'Leary.
Excellent summary. Okay, moving on from physical intrusion to deception. Fraud.
Governed by the Fraud Act 2006. This replaced a whole load of old, complicated deception offenses, didn't it?
It did. The Fraud Act 2006 aimed to simplify things. The old law was very technical, struggled with things like computer fraud, and often hinged on proving the victim was actually deceived and acted on it. The new act focuses more on the defendant's dishonest conduct and intentions.
And it's basically one offense of fraud, but committed in 3 different ways.
That's right. Section 2, fraud by false representation. Section 3, fraud by failing to disclose information. And Section 4, fraud by abuse of position.
Let's start with Section 2, false representation, the core idea.
Making a dishonest lie or misleading statement. The actus reus is simply making a false representation dishonestly. Key point. You just have to make it. The victim doesn't need to see it, believe it, act on it, or lose anything.
Like sending a phishing email. Crime's complete when you send it.
Exactly, even if no one clicks the link.
And representation isn't just words.
No. Section 2, 3, and 4 say it can be about fact or law, including your state of mind, like intending to pay. Express or implied. Conduct counts painting over rust implies the car isn't rusty. Using a stolen car implies you're the owner. Activity 12.19 has examples. Hiring a Rolls implies you can pay. Turning back an odometer implies lower mileage. Key exam skill. Spot the exact false representation. Activity 12.20 notes that lying about why you need to meet at 9 p.m. could be the false representation.
Can silence be a false representation?
Usually no, that's more Section 3 territory if there's a duty to speak. But silence can make an earlier true statement false if circumstances change and you don't correct it. Rise the case, failing to disclose the person needing the downstairs room had died, made the continued representation false. Illustration 12.5 Firth involved a doctor not disclosing a patient was private, held to be a representation by silence.
And crucially, the Act covers representations to machines. Section 2.5.
Yes, vital for modern crime. False online forms, phishing, even using a foreign coin in a slot machine that's representing it's the right coin to a machine. Activity 12.21. Putting the false ad in the window completes the actus reus.
How is false defined?
Section 2. Untrue or misleading, and the maker knows it is or might be untrue or misleading. That might be is quite broad.
So saying a painting is early Rembrandt when you know experts disagree, even if not proven wrong yet.
Exactly. Activity 12.22 explores this. Fake BMW mileage is knows untrue. Fake constable knows untrue. The Rembrandt example hits the knows it might be misleading point if attribution is genuinely debated.
And the mens rea for S.2 fraud. Section 2.1b.
You must intend, by making the representation, to make a gain for yourself or another, or R, cause loss to another, or expose them to a risk of loss. Intention for gain or loss risk.
Gain and loss are broad too. Section 5.
Yes, money or property, temporary or permanent. Gain includes keeping what you have. Loss includes not getting what you might get. Intention means purpose, or knowing it's virtually certain.
Examples. False reference for a friend's job, gain for another. Malicious damage causing loss, Janice hot dogs. Mortgage broker, lies exposing lender to risk, Allsop.
Perfect. Allsop is key. Exposing to risk of loss is enough. Activity 12.23 reminds us not all lies are fraud. Marriage isn't financial gain loss, but lying about a golf handicap for cheap membership could be fraud if gain loss risk and dishonesty are present.
Dishonesty test for fraud is the same as theft now. IV.
Yes, IV dishonesty applies. Defendant's factual belief, then objective standard of ordinary decent people. No direct equivalent to the S21. Theft Act specific beliefs, belief of entitlement, is just part of the facts for the IV test.
Okay, quickly on sections 3 and 4. Section 3. Failure to disclose.
Actus reus. Dishonestly failing to disclose info where there's a legal duty to do so must be a legal duty statute, contract, fiduciary duty, etc., not just a moral duty.
So the art dealer not revealing the true value, no legal duty, likely no S.3 fraud.
Correct, usually. Mens rea, IV dishonesty and intent for gain loss risk. Often overlaps with S.2 if silence makes something else misleading.
Section 4, abuse of position.
Actus reus, occupying a position requiring you to safeguard another's financial interests and dishonestly abusing that position. Act or omission. Think trustees, directors, employees, maybe carers. Judge decides that the position qualifies.
Mens rea.
IV dishonesty, intent for gain loss risk, cost forcing.
One more related offense, Section 11, obtaining services dishonestly, still active from the 2006 Act.
Yes. Actus reus, obtaining services by a dishonest act, where payment is expected but not made. Note, dishonest act broader than just deception. Illustration 12.9, the car park drive-off, is a classic dishonest act without necessarily being a deception to get in.
And obtaining services.
Section 11.2 defines it. Services available expecting payment, obtained without full payment. Indeed, the defendant knows payment is expected, or might be, but intends not to pay in full. Payment expected, got service, new payment expected, intended not to pay.
So, activity 12.24. Free pool sneak in isn't S&11, no payment expected.
Yeah.
Lying about age for discount is S.11, payment expected, dishonest act, intent not to pay full price.
Exactly. Mens rea is IV dishonesty, knowledge payment expected, intention not to pay fully. No theft act S.21 type beliefs apply directly.
And this can overlap with S.2 fraud.
Definitely. Lie about being a pensioner for cheap cinema ticket. Could be S.2 false rep and S.11 obtaining services honestly. See illustration 12.11b. But the car park drive-off, illustration 12.9, might only be S.11 if no false rep was used to get the initial service.
Fraud and obtaining services wrap-up. Fraud Act 2006 focus on intent. S2, false rep, actus reus making rep, false def, silence, machines, mens rea intent gain loss risk, IV dishonesty. S3, failure to disclose legal duty. S4, abuse of position. S11, obtaining services, dishonest act services def overlaps. Key cases, Firth, Ray, Alsop, IV.
Great. Final hurdle. Making off without payment.
Section 3, Theft Act 1978. Feels like a backup plan for prosecutors. For petrol drive-offs where theft or fraud is hard.
That's largely its role, a last resort. Activity 12.25 suggests for price swaps or mistaken change, you'd go for theft fraud first. Making off is plan B.
Actus reus. Knowing payment on the spot is required expected. Dishonestly makes off without paying.
2 bits. Makes off. You have to physically depart from the spot where payment is due. McDavid didn't make off stop before leaving the restaurant.
But Moberly v. Alsop, passing the ticket barrier was making off.
Yes, the barrier was seen as the spot payment was due. Activity 12.26 explores this spot idea.
Payment on the spot required expected. So, not if you're billed later. Or if payment isn't legally due. Wilkinson taxi fare.
Correct. And crucially, not if you deceive the person into letting you leave without paying now, intending to pay later, Vincent. That deception removes the on-the-spot requirement. Activity 12.27 suggests fraud is the better charge in Vincent's situation.
And the mens rea? Dishonesty A&D, intent to avoid payment of the amount due.
Yes, but here's the killer point from the case of Allen. The House of Lords interpreted intent to avoid payment due as meaning intent to avoid payment permanently.
Allen means intent to avoid payment permanently.
Permanently. This is huge. It means if you dishonestly leg it from a restaurant knowing payment is due, but you genuinely intend to come back and pay later, maybe you forgot your wallet, you lack the mens rea for making off. As the source says, this interpretation made the offense somewhat toothless.
Activity 12.28 contrasts this with Lawrence theft, where the court didn't read extra words in, but Allen effectively did, reading in permanently. Seems inconsistent and definitely weakened the offense.
It did. So, making off takeaways. S.3 Theft Act 1978. Purpose, last resort, actus reus. Makes off from the spot, McDavid, Moberly. Payment on spot, Rekex, Wilkinson, Vincent. Mens rea. Dishonestly and intent to avoid payment due, meaning permanently. Allen, remember Allen?
Wow, we have covered a massive amount there. Theft, burglary, fraud, making off without payment. Foundational stuff, absolutely.
Definitely. And for exams, mastering these means really getting to grips with the specific actus reus and mens rea for each and knowing those key cases that interpret the rules.
Focus on the definitions: property, appropriation, Gomez, Hanks, belonging, Turner, Wayne, Chadwick, Sagari, dishonesty, IV now, intention to permanently deprive, Delumo, Lloyd, Marshall, burglary elements, Jones and Smith, O'Leary, fraud methods, S2, S.3, S4, obtaining services, S11, and making off's permanent intent requirement.
Use this deep dive as your guide. Go back to the materials, look at those cases again, make sure you understand the distinctions.
Remember, this session comes from materials provided by the University of London, and it's brought to you by Sinorbit Academy, Sri Lanka.
We really hope this has helped clarify these tricky areas for you.
And seriously, to all students listening, The very, very best of luck with your exams. You've put the work in.
You absolutely have.
As a final thought, though, as you revise, just think about how much of this law hinges on proving what was going on inside someone's head, their dishonesty, their intention, their knowledge. How certain can the law ever really be about proving those internal states?
That's a deep question, and one lawyers and courts grapple with constantly.
Indeed. Well, that wraps up this deep dive. Thanks for joining us.